Good afternoon. Welcome to Long Live Third Parties Podcast. Free Press Media Press Inc., a third-party spokes publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Libertarian Party of New Mexico versus Herrera, 506 F3D 1303, Court of Appeals, 10th Circuit, 2007. Friends, today we're going to talk about the topic we love to talk about here. Yes, ballot access, as it goes for third parties. Once again, our friends at the Libertarian Party are pushing forward a case. So good job, Libertarian Party, for all your litigation. Not everybody wants to litigate, so we appreciate the fact you do so. It helps the case. It helps the cause. So what happened in this case? Let's read from the records. This quote: the Libertarian Party of New Mexico and several of its candidates for public office sought to be placed on the ballot in New Mexico for the November 7, 2006 general election. Failing to obtain the requisite signatures required under New Mexico's election law, the Secretary of State refused to place the candidates' names on the ballot. The Libertarian Party and 4 candidates brought suit for declaratory relief against the Secretary of State and the county clerk of Bernalillo County under 42 U.S.C. Statute 1983 and filed a request for a preliminary injunction alleging New Mexico's two-petition ballot access scheme unconstitutionally burdens their First and 14th Amendment rights. The district court granted summary judgment to the defendants and denied the Libertarian Party's Federal Rule of Civil Procedure 56 (F) request for discovery. End quote. Once again, our side is invoking the First and 14th Amendment. So many of these trials involve that. The vast majority do. So we love that. That's a good strategy. For any of us who may face ballot access trials ourselves, we can consider this strategy. This case deals with what they're calling here the two-petition ballot access scheme. So what is that? They describe it as follows. Unlike other states which require one petition, in New Mexico, they require 2 petitions for signatures. One is to get on the ballot as the party, and the second is to get on the ballot as a candidate. So friends, what do you think about that? Do you think this is irrelevant? Do you think it makes a difference? Our friends of the Libertarian Party think this makes a difference, so that's why they fight it. Our friends at third parties have problems with 1 petitions in other cases, so this is taking things to another level in a bad way. As they state, quote, the Libertarian Party alleged the two-petition ballot access system, which requires the party to first show a modicum of support and then show additional support for each candidate, imposes a substantial burden on the party's ability to have its nominees appear on the general election ballot. End quote. That sounds good to me. And I trust it sounds good to you. So what did the judges think of this? They didn't grant our side victories here, unfortunately. They said our side did not have enough evidence. And one issue they mentioned was the Libertarian Party, according to them, was trying to argue an issue they didn't bring up during the original trial. So we're going to give the Libertarian Party the benefit of the doubt. They had a lot to think about, so they can never be perfect. If we can in the future bring as much possible to the original trial so we can have it for appeal, let us keep that in mind. Otherwise, we're going to applaud the Libertarian Party for doing what they can. So let us keep that in mind, friends. So ultimately, the judges concluded as follows. Quote, for the foregoing reasons, the court affirms the district court's denial of the plaintiff's Rule 56 (F) motion and grant a summary judgment to the defendants. End quote. This gives us something to think about. It would be nice if we could overturn that two-petition system in Mexico, in New Mexico. It would rock. The Libertarian Party paved the way here. They put the first step into the process. So one day, maybe it will be overturned. Good job, Libertarian Party. Good job. Long live third parties. Goodbye.